Hi everyone, today we are talking about the main parts of an international contract. Let's start with offer and acceptance. In global trade, an acceptance only counts once it actually reaches the person who made the offer. This rule helps prevent any type of confusion when you are communicating across borders. The valued offer. A definite proposal showing intent to be bound must be specific regarding subject matter, quantity, price, and terms. The acceptance as well must match the offer exactly. Any change is a counter offer. So this means communication is key, as it must be made within the specified time frame or a reasonable period. Next up, we have consideration and mutual exchange, validating the enforceability of global promises. The concept of value is a legally binding contract. It requires a reciprocal exchange, so each party must provide something of value, whether that be goods, services, or financial obligations, to distinguish a contract from a gift. Legal traditions compare is as some countries call this consideration, as it must be real and sufficient, representing a bargain for exchange of value. Others just call it cause, focusing on the legitimate and lawful purpose behind the agreement. Contractual capacity. You have to double check that the person signing the paper actually has the legal power to represent their own company. If they don't have that authority, the whole deal could be canceled. So, the legal entities, meaning corporations, must have proper registration and board authorization, meaning signatories must have explicit power guaranteed by the board. And natural persons, meaning individuals, must have age of majority and sound mind, meaning capability to understand the nature and consequences of said contract. Governing law and jurisdiction are two different things. Governing law determines which national legal system will be used to interpret the contract's terms and validity. And jurisdiction specifies the location and authority that will hear and resolve any kind of disputes. For example, if we go down, in primary purpose, in governing law determines legal rules for interpreting terms, and jurisdiction determines where these disputes will be resolved. For example, in governing law would say this contract is governed by the laws of New York. In jurisdiction says disputes shall be resolved in the courts of Paris. Very different things. Dispute resolution. Most international deals use arbitration instead of regular courts because it is much easier to enforce those decisions in other countries. International arbitration has global enforceability, neutrality and choice, and high confidentiality, while litigation, the traditional way, has limited enforcement, procedural delays, and public proceedings. Performance and delivery. Standardizing responsibilities with Incoterms. The key Incoterms in national and international deals are FOB, CIF, and DAP. FOB focuses on seller delivers the port, buyer assumes risk, and the cost after goods are loaded. The CIF is based as seller pays freight and insurance to destination port, risk transfers at loading. And DAP centers as seller bears all costs and risks until goods arrived at the named location. Now, a very important part of international contracts: secure payment mechanisms. A letter of credit, a doc collection, and a wire transfer are very, very vital to these contracts. As a letter of credit is a bank issue guarantee ensuring payment upon presentation of specific documents, for example, a bill of lading. A doc collection is a seller's bank sends documents to buyer's bank, released only upon payment or acceptance of a draft. And most importantly, wire transfer. Direct electronic transfer, fast and cost effective, but requires high levels of trust. Moving on to force majeure is managing the unforeseeable in global trade. The actual definition is that extraordinary events beyond a party's control that make performance impossible or impractical. The common triggering events are pandemics and lockdowns, natural disasters, war and conflict, government embargoes, and labor strikes. Now, to wrap up the class, we are going to move forward with our conclusion. International contracts are the essential foundation of global economy. They serve as a clear roadmap for businesses operating in different countries with different rules. By defining every part of the deal, from who is in charge of shipping to how a disagreement will be handled, these documents create a safe environment for trade. The real importance of a strong contract is that it provides continuity in an unpredictable world. It turns a risk cross-border deal into a professional partnership that can survive challenges and help businesses grow together. I have my 3 references up here, and it would be all from our class. Thank you.